We now recall cause number 23 CR 203, the state of Texas versus Asia Kiani Young, who is present with her attorney, Mr. Turk, and the state's attorney, Mr. Hamp, are present. Earlier, the defendant pleaded guilty to injury to a child with intent to cause serious bodily injury. This is a first-degree felony under our law. That was what she was indicted for. She later pleaded guilty to a lesser included third-degree felony of injury to a child. Is that what it was?
Well, Judge, we actually, in prior proceedings, the indictment was amended on the record to reflect a third-degree felony.
Okay. In lieu of causing serious bodily injury, as it was earlier indicted, the defendant pleaded guilty to intentionally and knowingly by omission causing bodily injury and mental deficiency to the child 14 years of age or younger.
Correct, Your Honor.
That's 2.04, subpart A, subpart 3 of the Texas Penal Code. A person commits an offense if the person causes bodily injury to a child and an offense is a felony of the third degree when the conduct is committed intentionally or knowingly. Everybody agrees it's section 22.04, subpart A, subpart F. Now look at.
Yes, sir. That is the proper punishment.
And the agreement here under this third degree felony is whatever sentence shall not exceed a cap of 8 years confinement in prison. So we're looking at no less than 2, no more than 8 years confinement. Deferred or unadjudicated probation is an option. And I think regular probation is also an option as well. 3 different options are available. Have the court had have the parties had an opportunity to review the pre-sentence report that has been prepared by the probation office, and are there any corrections or changes to it, State?
State has, and we have no objections or changes, Judge.
Defense has read it, and we have no changes, Judge.
All right. Statement open and close. And also, did y'all have a chance to read? There were some letters that have been sent and to the court. 1, 2, 3, 3 of them.
How about them?
Or looks like from our family members because they were like they were typed on the same.
They were emails to me, Judge.
Same device. Then you've got 2 other letters that have been submitted to the court on behalf of the defendant. All right.
So I am going to open and close on this one, Judge. Just in fairness to Mr. Turk, I want the record to be clear that what I'm asking for is the 8-year cap on this. I feel like leniency and all that was addressed when a prior prosecutor adjusted this lady's charge down from a first degree to the third degree. I want to point out before the court moves into listening to other comments that the co-defendant on this matter received 35 years. And that was a negotiated settlement at the time of trial docket when the exposure could have been higher. I mean, it was obviously a first degree felony, but that sentence is just and proper and addresses the actual serious bodily injury that was done to this child. So with those comments, I'll wait to make the rest of my argument in response, Judge.
Okay. Mr.
Judge,
Turk.
what Mr. Dylan Banks Senior did to the child, he was the one that actually committed the injuries to the child when Mrs. Young was not present. No one, and to include Mrs. Young, is trying to justify her delay in seeking medical care or excuse her delay in doing so. She has been remorseful. She has pled guilty. She is taking ownership of this. She voluntarily, if I understand correctly, spoke with the police and admitted that she apologized for what she did. She said what she did was wrong. But she was not the one that physically injured the child. She's the mother. She did delay in getting medical attention as she's pled guilty to. But she did eventually the child eventually got medical care.
How?
At Children's, I think they
Texas Children.
Texas Children.
How did the
I
child
think
get
they- you called and
Yeah,
when?
probably several days later.
First of all, what's the status of the other defendant?
He received 35 years.
And for the court's edification, Mrs. Young and Mr. Banks Senior, their parental rights have been terminated.
Mhm.
And my understanding is a child from what I saw in the PSI, the child has been adopted. Mrs. Young does have 3 other daughters, 2 of which have submitted letters to the court along with her ex-husband. The father of those 2 daughters, all in support of Mrs. Young finding leniency from the court. There's 2 other letters from Ms. Martin and Mrs. I apologize. Warren, sorry about that. And support hers, kind of detailing Mrs. Young's past where she's had abusive relationships. She's had bouts of homelessness. Her parents had issues with mental health and whatnot. She's had a tough life, Judge, and she's tried to manage. And then the other letters say that she has been a caring mother. They haven't had any issues such as this. My understanding is that Mr. Banks Senior was an evil person, to put it lightly. He manipulated the family and did things that were just evil. And that's not to excuse what Miss Young did. She's not here. She's just simply asking the court to take into consideration that she has no criminal history. This is not who she is, but she's willing to take ownership of it and whatever remedy the court finds appropriate. She's willing to take parenting classes. She has had a history of cognitive issues in the past. She does understand what's going on here, but she would ask the court to grant her probation, deferred preferably, so that way she can get back to parenting, taking parenting courses to improve her parenting skills and improving her relationship with her family. And that since we have a history of in the court looking at people's past for harsher sentences, I think we should take a look at her history for the fact that she doesn't have that baggage that some people that come through this court do. She has not been a problem in the court, as had been demonstrated by several other cases of recent note. But she is indeed remorseful of what happened. But she wants to move forward if possible with her life, but understanding that what she did was wrong.
I don't know. I would see.
All right. Anything else?
No, Joseph.
Did you want to say anything, man?
no, sir.
Okay. Go ahead. Stay.
Yeah.
All right, so clearly, we're only going to hold this lady responsible for her conduct. And as the indictment is here, it's all about her omission. She admits to police officers that She knew that the child had been injured and didn't act. Every minute that goes by impacts someone who's suffers serious bodily injury. And this situation was no less than 2 days, but could have been up to a week before the incident. So to label the other co-defendant as a monster and was responsible doesn't necessarily accept the responsibility for the parent of the child, who has the responsibility to do more than what she did. She did nothing whenever she knew that her 5-month-old child was suffering. That conduct in and of itself warrants prison time and does not warrant probation. One thing of note in reading her family support, which I'm glad she's got family support. It's a good thing. The court notes that often we stand in here and we don't see that. What I note in reading all of these letters is not one word is mentioned of Dylan Banks Jr. That's the name of the child that is the victim of this. Nobody offers sympathy. Nobody offers care. It's all about her. And to some degree, you can understand it when it's the individual. But the bottom line is she's responsible by her lack of conduct for the resulting injuries that this child has. The grace given to her, the lenience given to her was to say it wasn't serious bodily injury, and it clearly was. That changed her dynamics. It dealt with the fact that she has no criminal history. And although the state wasn't aware of her history, nothing in that history about what's happened to her warrants this. It doesn't minimize it. It doesn't help explain it. In fact, if anything, the fact that she had bad treatment as a child should have made her more on edge to where she would do the right thing for this child, which she did not. And I probably will be repetitive about the fact that Dylan Banks Jr. is not mentioned by anybody, and he is the victim in this. When I read through this report, I agree with, and I probably should have led off with the fact that the officer, when they get down to this recommendation, says that the seriousness of this offense warrants a significant consequence. That's as close as I've ever seen in my 36 years of practicing law, a probation officer saying that they need to go to prison. Often what we'll hear from the other side of this bench is because they write the potential terms of supervision that they're recommending probation. They're not. They're just telling Your Honor what should be done if we get there. Another glaring fact that does not help Ms. Young at all is when we look at page 2 under her family structure, she suggests to the interviewing PSI officer that she's got living arrangements. So being a good officer, that person goes and checks. That individual has not been talked to at all, is not one of the supporting letters, is not somebody that said, hey, yeah, I'm ready for her to come live at my house. I started out saying, and I'll end with saying, what happened to Dylan Banks Jr. warrants a prison sentence, and in my suggestion, it should be a term of 8 years.
All right. Anything to add? By anybody? No. No. Okay. The court is making some changes that need to be made in the documentation in the pre-sentence report. The indictment is before the court from the pre-sentence report with the pre-sentence report, but it does not have the corrections where the indictment was corrected from a first-degree felony to a third-degree felony. And also deleting serious bodily injury versus bodily injury. And all of that is for technical corrections in this report. Because the defendant was initially indicted for a first-degree felony, it was later reduced to reflect a third-degree felony of injury to a child rather than serious injury to a child. And that the change of intention to intentionally and knowingly in the culpable mental states to cause bodily injury and mental deficiency versus serious bodily injury or serious mental deficiency were corrected and amended by the agreement of the parties, which changed this punishment range from a first-degree felony to a third-degree felony. This is why, and then the resulting agreement of a cap of 8 years. What is brutally honest about the facts of this case is that a 5-month-old infant, the defendant's child, on January 20th of 2023, and this is now 3.5 years ago, was brought to Texas Children's Hospital in Houston by the defendant and Dylan Banks Sr., who were the parents. And the evaluations from the Children's Hospital revealed that the child had suffered serious injuries indicative of abusive trauma, which included multiple rib fractures, brain bleeding, brain tissue damage, bilateral retinal hemorrhaging, bruise to the neck, potential spine injuries, and was suffering from seizures. This was deemed critical injuries. The child was placed on a ventilator shortly after the admission, and then Child Protective Services and the Houston Police Department were alerted. And during the investigation, Banks' father admitted to shaking the child on January 13th, which would have been a full week before the child was brought to the hospital for care. And when this defendant was interrogated by and questioned by authorities, the defendant acknowledged her awareness of the abuse inflicted by the father, and that he had texted her around January 18th, which was 2 days before the child was brought to the hospital, claiming that the child had stopped breathing, but he had revived him. And despite learning of signs of distress and bruising on the child, Asia Young, this defendant, did not seek immediate medical help or report the abuse, and claimed that she did that because she was in fear of the injuries being discovered by the authorities on the child. And consequently, it was determined by the investigators that the defendant had intentionally or knowingly caused serious bodily injury to the child through her inactions and failing to fulfill her legal obligation to provide necessary medical care. But that charge was later reduced by agreement by the parties to bodily injury rather than serious bodily injury. According to the recommendations from the probation office in the preparation of the pre-sentence report, it was summarized that given the nature and circumstances of the offense, the significant harm suffered by the victim, and the defendant's failure to take appropriate action despite having a duty to protect the child and obtain medical care for the child, the officer believed that the seriousness of the offense warrants a significant consequence. And truly, who wouldn't? This, once again, I'm like deja vu all over again with an infant child barely out of the womb, 5 months old infant, suffering severe injuries, and then the people who were responsible or knew about it and were responsible for action hesitated and delayed. And thus, by failing to act, caused more of a dangerous predicament to the child, who in 5 months is literally helpless to take care of itself, but must rely on our creator and our nature, and the nature that allows the parents, the responsible parties to the birth of the child, to assume the responsibility of proper care, which was not done in this case. I don't believe anybody contends that this defendant had anything to do with actually directly harming the child. Isn't that right? I don't see anything in those four quarters. But days went by before the child was brought to help. And that is a parent's responsibility, in spite of the other parent being viciously responsible. And that's what resulted in his 35-year sentence. Now we're dealing with someone who may not have had direct contact with the harm of the child, in the harming of the child, but yet had a natural and creator-given responsibility and a lawful responsibility to seek emergency care as soon as possible. And that delay put this child into harm's way, greater harm's way, by continuing to suffer those serious bodily injuries. I mean, a child can't go along with brain bleeding and multiple rib fractures and brain tissue damage and retinal hemorrhaging. And those are going to ultimately probably result in long-term disabilities for the child during its life. So that's where we are on that. Anyone add anything? State,
No, Judge.
defense,
You've summed it up.
ma'am, you want to say anything else? If nothing further, I'm going to find that Asia Young, the defendant in this case, has pleaded guilty to the third-degree felony of injury to a child. Voluntarily, you have pleaded voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at this guilty plea hearing, which admitted responsibility under the law to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony of injury to a child. And I'm following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 8 years confinement. A parent has a very special obligation. This is a duty. And you delayed knowing that the child was injured. And the child is lucky that the child did not pass away, but we can all use reasonable thought here under these injuries that the child may very well suffer long-term, if not lifelong, harm from the delay that was caused because the responsible parties did not either act correctly at the beginning or did not seek medical care when the parent was aware that the child needed help immediately. Child is helpless with their 5 months old. That's why the parent's duties are strict under the law, and the law provides serious penalties when the parents do not act responsibly. This court finds that under these circumstances, the sentence is fair and appropriate, and also sends the message that a 5-month-old, all children's lives are not only important, but are dependent upon, and their well-being are dependent upon the parents, the caregivers' responsibilities to deal with any problems immediately and responsibly. And this child was not dealt with properly, as a parent should deal with child's injuries. Thus, this court finds this to be a just sentence under these circumstances. Anything else?
Okay.
That is all. We are in recess on this case. All right, we're going to be going into voir dire here in a moment, and we'll be done while we pick a jury.
Thank you for watching. If you found this video informative and helpful, please like, share, and subscribe. To support our mission of spreading legal awareness and delivering just